Hi, welcome to today's webinar. I see that we have some people joining, so I'll give individuals a chance to join while I'm making these initial announcements. My name's Nicole, and I'm with the San Diego Law Library, and I have here today our speaker, Kevin Greene, who will be discussing AI, intellectual property, and African American creators. I just have a couple of housekeeping things to do before we get started. So first, for those of you who are here for CLE credit, we will be issuing a participatory MCLE certificate for those of you who are verified to have attended today. So please be looking out for that in your email later this afternoon. This class was originally advertised as general participatory MCLE credit. However, this class will cover the elimination of bias. Thus, your certificates will be for 1 hour of elimination of bias participatory MCLE credit. This is also an interactive presentation, so you'll have the opportunity to pose questions for our speaker, but we kindly ask you to use the Q&A function. And under the Q&A function, you may ask questions with your name or anonymously, whichever you feel comfortable with, and we'll try to get to as many as possible today. Lastly, you'll also receive a link to a survey at the end of this presentation. We would really appreciate any of you who would take the time to complete that survey and give us some feedback on today's presentation. And with that, I will turn things over to our speaker, Kevin Greene.
Thank you, Nicole, and thank you, San Diego Law Library, and particularly you, Nicole, for inviting me to this presentation, and everybody who's here on a Saturday morning or now Saturday afternoon for this presentation. Hopefully, it'll be worth your while, and you'll give feedback regardless. So anyway, a little bit about my background. I was born in Jamaica, Queens, but this is relevant because my grandmother lived in the South Bronx, so we spent a lot of time in the South Bronx. During that period of my childhood. It was there in the South Bronx where we used to get our haircuts at the Black Barbershop in the Bronx, sometimes in Queens, but a lot of times in the Bronx, that I really started thinking about this issue of intellectual property and social justice through the lens of African American artists. And of course, in that barbershop, nobody had a PhD, I guarantee you. Most of them didn't even have, high school degrees. But they would talk, and in their conversation as a kid, I got that there was something terribly wrong about our system. I didn't know anything about copyright, trademark, or publicity rights, but I saw that these artists who were creating the blues and jazz and hip hop and everything else, they really weren't compensated. And the people in that barbershop knew that. They knew that something was terribly wrong with what I now understand to be the intellectual property system. So much creativity on the part of these artists. And there you can see in my slide at the bottom, somebody scratching on a record. So I was literally as a child in the South Bronx during the 70s at the very beginning of hip hop, another great innovative form that came out of this community. And yet many times outside of a few stars who, make some money, people aren't really being rewarded, which is what an IP system is supposed to do. It's supposed to reward creativity and inventiveness. So I really didn't have a way to process this until I actually went to law school. And I was in the Marines first. As you can see there, somebody loading bombs and missiles. That was my job. You see the guy in the back. That's not actually me, but I kind of pretend that it is. And being in law school, even though it was quite difficult and often frustrating, it did give tools to actually analyze these types of problems for it. There's Cravath, Swaine and Moore, which is a big Wall Street firm I worked for. At that time, it was on 50th and 8th Street. I think they moved downtown now. So I was basically after law school and being in the service, into the world of corporate law and entertainment law. But before I actually started working as a lawyer in that big firm, my first client was HBO, if you can believe it, Warner Brothers, along with 10 other attorneys, of course, on the team. When I was a law clerk on the Michigan Supreme Court, which I did right after law school, they told me to go get this guy who was going to be speaking at the Wolverine Bar Association, which is the African American Bar Association. And being the junior person as a student, they said, or a recent graduate, they said, go pick up this guy. Well, that guy happened to be Derek Bell, who's known as the founder of critical race theory. And I listened to Derek Bell, not understanding a lot of what he said, except that I'd never heard anybody speak like that before about this foundational issue of race in America. And I also knew that I would never be the same after listening to Derek Bell. So I credit Bell with a lot of the work I did as an inspiration subsequent to that. When I left the big firm, I went to work for a boutique, and that boutique is the leading boutique in New York City, and they represented pretty much everybody. Some of the clients I work with, or they directed me to, was Spike Lee and his motion picture company, Bobby Brown, the great king of R&B, as they called him, and of course the seminal rap group Public Enemy. Public Enemy. While I was there at that firm, Chuck D was our client, and he sued the St. Ides malt liquor. This is my first introduction to the right of publicity, which is part of the intellectual property family. The company that makes St. Ides malt liquor did a radio ad that featured Chuck's voice. Excuse me. However, they didn't have his consent to do that. And that is a violation of this area of law we call the right of publicity. This ended up being an extremely costly mistake for the company that makes St. Ides malt liquor, particularly because Chuck D was adamant that he did not support the sale of cigarettes, tobacco, and high content alcohol like St. Ides in these inner city communities. So they had to pay dearly in a settlement, and it was me who took the check to Chuck D in an undisclosed location. I had to go to the bank, draw the check, and take it to him. And that was one of the heights of my legal career because I had idolized Chuck D and Public Enemy when I was in law school. Okay, I've done a lot of scholarship in this area around copyright, trademark, and publicity rights. We'll talk a bit about copyright today and publicity rights. We won't really be talking about trademark, but there's Cardi B, and of course she's holding that Pepsi can because she endorses Pepsi. And that is how today's entertainers get paid in the modern music industry. They won't get paid from Spotify at 0.0000089 cents for every Spotify hit. So now they have to do other things, and that's what this article that just came out in the Chapman Law Review, intellectual property. Well, no, I'm sorry. My first article was called Intellectual Property Expansion and Publicity, and it talked about the many problems of this area of the law, some of which we can discuss today. The newest article is called The Rise of Trademark Rights and Publicity in the Hip Hop Music Arena. That just came out, what, a month ago in the Chapman Law Review. It's my second go around with them. But I like Chapman because both times they paid me not only to speak at their conference regarding this, but they also paid me for the article. So that was very sweet. Thank you, Chapman Law School. Okay, so I'm a professor at Southwestern Law School. I'm the John J. Schumacher Chair Professor, and this is just some snapshot of the scholarship that I've done around the area of social justice in the IP space. Copyright Culture in Black Music, the first article back in 1999 when I was a young professor. The first article about this topic, the very first. And since then, a lot of people write about this, but I've written about copyright and gender, about trademark law and how that's impacted race relations, copyright terminations, copyright registrations, and a whole bunch of stuff. And the last one is the Copyright House of Horrors. It's my graphic novel about all the issues that I put in the scholarship, but it's written as a novel that hopefully people who don't even know anything about IP will enjoy simply because of the story. Okay, I'm gonna skip through some of this. In this latest article, Goodbye Copyright, they just talk about how this area of rights of publicity, the ability to protect your name, your likeness, your image, to in essence sell yourself, the brand yourself, is now the go-to regime. And it's very much in the lens of AI, which we're going to talk about here shortly. Let's skip through this. Finally, just by way of background, I do work. I'm active as an expert witness in these cases. Actually, I just testified yesterday in San Diego Superior Court about this case with the lemonade. That's Coca-Cola. They made this product called Hubert Lemonade. However, they didn't have the rights to actually use Hubert's name. That's the founder of the Hanson Juice Company, and that's a multi-gazillion-dollar case against Coca-Cola. George Clinton really changed everything for me. Back in 2014, it's 10 years now, I was at a conference and someone ran up to me and said, "We need your help." And I said, "Okay, who is we and what's going on?" And the we was, this person was a part of George Clinton, who is one of the greatest American artists ever. He's at the center of funk music, along with James Brown. And of course, he was being sued in court. It actually was in the Ninth Circuit now. The case was already over on appeal. The question was whether or not a lawyer that he owed money to, a law firm that he owed money to, could take his music, his sound recordings, to satisfy the debt. We fought the case tooth and nail. We lost in the Ninth Circuit. And it just kind of reaffirmed what I already know, is that the federal courts are not very sympathetic to these artists and seem to be, I don't want to say looking for ways for them to lose, but certainly not showing them any kind of deference for it. We didn't win that case. He had to cough up those sound recordings, and that was a real emotional blow, because this has happened time and time again to these artists. Okay, my work has done an extensive look about how the American music industry has extractive practices that they used against white artists and everybody else, but they were perfected against African American artists, starting with blues music and maybe even going back to ragtime. That's Frankie Lyman and the Teenagers. They did a song that was a massive hit in 1956 or so called "Why Do Fools Fall in Love?" And I just say this to people because sometimes people say, "Well, why are you talking about that old music?" Two things. Number one, all that old music from the 1930s, 40s, 50s, 60s, 70s is still under copyright and will be for some time. Number two, these artists, we're taken advantage of, and there's just no way that we can allow this and have a system that is credible in the eyes of the people. It doesn't work that way. All of these works are still making money. So if you understood how music publishing works, you would know, and some on the call may, you would know that if you own the rights to a 1956 song, "Why Do Fools Fall in Love," you probably wouldn't have to work again. That's how much a song like that, old as it is, still generates. And there are obviously many, many more like that. So I'm being a little sarcastic here, because when we talk about intellectual property rights, IP regimes, IP intellectual property, we think about this as the IP family. It consists of patents, useful inventions, medical products like drugs that you take. All of those can be patented. Everything that's in your cell phone, there's probably 3,000 patents just in that little cell phone we carry around. We're not going to talk about that. Copyrights, we'll talk a little bit about trademarks. Trade secrets, the right of a business to maintain a secret, like the recipe to Kentucky Fried Chicken. No one knows what it is. As long as they can keep that secret, they can keep a trade secret in that forever. And finally, the right of publicity, a newer right, but a very, very important one. The right of people to commercialize their likeness and their image. When we think about that, we think about the subject matter, what's covered, how do you get those rights for it? And we could talk a bit about that, but I think about IP regimes differently, right? Because there's been this deep historical exclusion between these creators, including Ruth Brown. Ruth Brown, a 1950s and 60s artist, the queen of R&B, one of the foundations of that, who was so prolific in her recordings and her record sales that they called Atlantic Records, now part of the Warner Brothers family, the house that Ruth built. Yet this woman had to work as a maid. No, nothing wrong with that, but she had to work menial jobs in essence and really didn't receive anything. And of course, there is Aunt Jemima, who was protected under the trademark law until George Floyd got killed, and the company decided this brand was no longer tenable, the Aunt Jemima brand. By the way, the Aunt Jemima brand was like $1 billion brand. So that the face and likeness of that woman, Nancy Greene, was used to make this company into a $1 billion company. And yet, as far as we know, Nancy Greene received little, if anything, for her lending her image to this brand. Okay, let's talk a little bit about AI. Of course, AI has shaken up the music industry and every other industry that we could imagine. My article, which I included in the materials I sent to Nicole, is about this. It says it's called Grenade, AI and its impact on marginalized creators for it. I've represented Warner Brothers, yes, but I'm not worried about Warner Brothers. I'm worried about the people at the bottom, regardless of what their race is. And I use race as a proxy to talk about this problem because African Americans have been at the bottom of this economic and social totem pole. So they're like a canary in the mine. How they're being treated is probably indicative of how other people are being treated in the industry, right? Now we have AI, and of course, this is a library we're speaking at. Libraries love the public domain because that means works that are no longer under copyright or protected under IP. Everybody can use them. A wonderful thing. Copyright only lasts for a set duration. But now AI is going to totally reinvigorate all those old public domain works. And in fact, we know that AI can put Jimmy Dean in a movie, and it did. James Dean, the iconic actor from the 1950s. His heirs or whoever owns the rights to his image gave permission to make a whole new movie with James Dean, sounds like James Dean, talks like James Dean. AI can do amazing things. So the public domain is going to be reinvigorated. My take on this, though, again, is contrary to most. And my thought is, yeah, but what about all those people whose works are in the public domain now who never got paid the first time? Is it right that now they be, in essence, re-victimized again? I was watching a show on Netflix called Reacher, terrific show. And they play a lot of blues music in Reacher because it's set in the South. And it's almost like blues is like the soundtrack for this Reacher Netflix program, which did very well for Netflix. And of course, that's one of the blues artists. I believe that's Blind Lemon Jefferson. And again, guys, people like him were never paid anything. And some of these people are still alive, although a lot of them have passed away. But the point is, all this music from the 1930s, 40s, 50s, 60s, 70s is still under copyright. And it's creating fortunes. And AI is only going to accelerate this. And as part of that is good because now a whole new generation will be exposed to the blues and ragtime and all these other great things. But on the other hand, there's an economic deficit there that these works are still monetized and the heirs of the people who created it are receiving nothing. That doesn't sit well with me. So generative AI, what is it? One of the delightful things about being involved in AI now and being a speaker, this is my 5th presentation on AI related issues in the last month and a half, is that the first one was at USC Law, their huge conference, a huge entertainment law conference. I was on a panel with an attorney from Shepherd Mullen, and it was my first one, and I was terrified. Like the song said, at first I was afraid, I was petrified, because I am not a tech person at all, by any means. I'm a music person, a movie person, I'm not a technology person. And I said, oh man, I got to speak in front of 500 people at USC Law School, all these practitioners, and I don't know anything about AI. What was delightful to learn, though, is I didn't have to understand all the technology and intricacies and neural networks and, machine learning models in order to be able to do the IP work here. So that was a delightful thing to me. And I still don't know all the intricacies of AI and probably never will. But what we do know about generative AI is that it basically takes massive amounts of data, so-called trains that data, and it can create new works out of it. That's all that I needed to know. I don't really need to know much more than that as a copyright lawyer or copyright professor to understand it. So I gave my first talk on this, I gave at UC Berkeley about a month and a half ago or so. And I was feeling it that day. And when we say feeling a certain kind of way, that's not a good thing. If someone tells you I'm feeling a certain kind of way about this, it's not a good thing. I was feeling that way, and I'm still feeling that way 5 talks later about AI and copyright and intellectual property. One of the things, of course, is that as I sit on panels and give talks about this, and I hear other people talking about it, well, we're focused on the law because we're lawyers, right? However, I don't even know if lawyers and judges should be making these decisions about AI, which impacts all of society in a profound way. It seems to me it's very undemocratic that it's going to be courts that make these decisions. That was one thing that I was feeling. The other thing I was feeling about was the academy, and how the legal academy is basically going to address this and deal with this. And are they really going to focus on what's really happening rather than these theoretical paradigms that sound great but really aren't reflecting what's happening on the ground? That's Ralph Ellison in that picture. He wrote a book in the 1950s called Invisible Man. It's one of the greatest American novels ever written. And if you haven't read it, you should read it, because even though it's 60, 70 years old, however many years old it is, still very much under copyright, by the way, it's the best description of race relationships in America, even so many years later. And in that Invisible Man paradigm, we're wondering who's going to be invisible in this new AI revolution that we're having. Are the same people who always get left behind going to be get left behind? And this is new and we're early on, but right now the signs are not good. They're not looking good. Was also feeling a certain kind of way because we still have segregation in America, and it shows up in this tech space. This is a white space. This is a space, a white male space, quite honestly. Aren't even that many women involved in it. And these are the people who are making these decisions that affect everybody. And I'm just not sure if they can be trusted, particularly when many of them are on record as not being trustworthy. I'm talking about you, Mr. Musk. That and these arcane copyrighted IP decisions by these courts are going to decide our future. That just really doesn't seem to me the best venue or vehicle to do it. That's why I was feeling a certain kind of way. Okay, so Professor Ori LaBelle is a brilliant professor right here in San Diego. She was my colleague when I taught down here in San Diego at University of San Diego. And a few years back, she wrote a book called The Equality Machine. And the Equality Machine is basically talking about the ways that AI can actually help us in all these dislocations we have in our society with gender, with race, with economic inequality, which is massive in our country. And I want to be happy. I tried to be happy, but I can't be happy. And right now, this dream of AI as an equality opportunity is not unfolding, and is not unfolding in the IP space. And that's what I'm here to say today. We don't have to accept this, and I'm still thinking about it, but there are some who are writing the whole infrastructure of the internet was built to support what this person called white supremacy. And there, of course, is Elon Musk. Certainly not the person that I would trust for a social equality experiment if I was going to perform one. There's lots of evidence, and this has been true in the tech space before that new technologies can cause more exclusion rather than empowerment for it. We have to keep our eye on that. And my whole thing is this industry, this new AI industry, is not going to think about this unless we force them to think about this. The profits are rampant. They're out of control. The billions that are being made and untold more billions. And so people who are in that position aren't necessarily going to be thinking about what's best for our society. They've shown no indication to do that so far. And everything we know with social media, et cetera. So we can't be complacent about this. We don't even have a lot of white women in the space. So that in itself is kind of a scary problem. Okay, there are in Hollywood, where I have my second residence, we had this big writer strike, and I see them out there every day. And the strike was about AI. The heart of the strike by both the writers and the actors was that they were going to be pushed out of the loop. Now, most people in America don't have unions. Only because the writers and the actors had unions, they were able to negotiate provisions that says, hey, movie studio, hey, television streaming company, you cannot cut us out of the loop and replace us with artificially generated images. That's exactly what the strike was about. But most people don't have that protection. So what about the rest of us who don't have that kind of protection? On the copyright side of the fence, the big question is training these massive data sets which is how AI operates, to create new works copyright infringement. There's Sarah Silverman. She's a funny lady, and she has a suit among many others about this very question. The short answer is we don't have an answer right now. There are so many lawsuits on this out there in the pipeline. And our legal system, the way it works is it has to go through federal court at the trial level, then the Ninth Circuit, our appellate circuit, and then finally the Supreme Court. By the time all that happens, that's going to be 2, 3, 4, or maybe even more years from now. And so my prognostication, for what it's worth, is that we're not doing this. We're not doing these lawsuits. That this reminds me of sampling. We're in the rap industry. Where in the beginning, everybody was sampling other people's records. There was no clarity on whether that was legal or not. Finally, we got a few decisions that said, yeah, if you sample from someone's record, that is copyright infringement. If you take something off of somebody's record and put it on yours. And that when that happened, the industry, everybody just said, let's sit down and let's work out a licensing regime. And right now, that's what we have. So if you need a sample, there's a whole mechanism that you can do it, and you can do it legally. My take is that's what's going to happen here. There's way too much uncertainty as to whether or not AI really is copyright infringement. one of the doctrines that we would have to apply, for example, is fair use. Is it fair use for these big AI companies like OpenAI? They're all the same companies, by the way. They're Google and Microsoft and all the same companies. They jumped into it. Are they really going to roll the dice on a fair use analysis of AI? Which basically fair use, if you know anything about it, no one knows how a fair use case is going to turn out ever. So I don't see that happening. I see the psychic in me sees a licensing regime where people will license their works for use in AI data sets. And there's already some of that going on. Authors like Sarah Silverman and musicians, etc., don't like obviously seeing their works swallowed up in this giant AI machine and spit out as a new work based on their work in essence, right? A different work, but still based on theirs. And usually copyright law says you can't make a derivative work. You can't adapt somebody else's work. That's all of what's at issue in these cases. Okay, I'm going to skip past some of these. Okay, let's talk a little bit about the right of publicity. I just talked about copyright, like for a cup of coffee, but let's talk a little bit more about right of publicity. There is Taylor Swift, and of course, like Cardi B, she's holding a soda can. This time it's a Coke can, not a Pepsi can. Why? Because this is what the right of publicity does. It allows a Taylor Swift, a Cardi B, a Jay-Z, pick who you want, to actually monetize their likeness, including aspects of their identity, their face, their picture, their name, even their so-called persona under this right in California. And that's why it's so important to entertain, is arguably for musicians more important than copyright, since no one can make money selling songs today. Not significant money. There's Doja Cat, and she's repping Skechers in the picture that you can see there. So right of publicity is a form of intellectual property, and it says that individuals, both living and dead, can stop someone from using their name, likeness, portrait, picture, persona without authorization when it's being done for commercial purposes. Right now, today, in October, this is governed by state law, but as I'll show you, there's a whole federal the Congress is looking at making a federal right of publicity that would apply across the nation. Let's see if they can do it. In California, we have a great right of publicity regime. We have a common law right of publicity, and we also have a statutory right, which is a good right because you can get attorney's fees and lots of other goodies and statutory damages. So it's a fun regime under 3344 of our civil code. This is the case that was at issue when I testified yesterday in that case. The case is called Hansen versus Coca-Cola. This case has been going on for years, unfortunately. So the things that the right of publicity protects is name, likeness, portrait, picture, photo, voice. All of those are protected. And there's been cases involving Tiger Woods, Vanna White, Woody Allen. We don't have time to go through them all. There's Beth Midler, a very important case from the 1980s that is getting new life because of voice replication by AI. I'm going to skip through some of this. So, a way of thinking about the right of publicity is it helps people monetize their fame by getting celebrity endorsements, endorsing products, appearances in nightclubs and anywhere else you can imagine, use on merchandise like t-shirts and the like. It helps celebrities and artists monetize all of that. So it's a great right. When we look at the right of publicity from an historical lens, it's not a great look along with trademark, because all of these people that you see in these ads were actually based on real people, and I'm sure none of them got paid. And also, as you can see, this is a very very discriminatory use of their images. I told you about Aunt Jemima. There's an early version of Aunt Jemima, and she's speaking in Black vernacular. Darky toothpaste. So all of these things didn't go well, obviously, for these people at that time. And I've written a lot about this. If you want to know, I'll send it to you. The cream of wheat chef was photographed and they used it, but we don't even know what his real name is, which probably tells us he got paid nothing for being the face of the cream of wheat brand until they finally took that off. Let's jump to the future now. We've got AI vocal replicas. Digital replicas are your voice. We saw this with this case a year and a half ago involving Drake and The Weeknd. This song, Heart on My Sleeve, was not performed by Drake or The Weeknd. It was created by AI, which clearly trained on the voices of Drake and The Weeknd, and it made a new AI song, which people liked so much that they said it should be nominated for a Grammy. And then they found out it was AI, and the Grammy said, "No, we're not doing that. We're not, we're not authorizing AI replicas." So this is a big deal in the IP world now, something that everybody's talking about. Now, let me just tell you something real quick. This is not a copyright infringement situation because the people who that made this song "Heart on My Sleeve," the AI song, they didn't use any of the lyrics of Drake or The Weeknd, and they didn't use any of the music of their record labels from the record. And so, therefore, no copyright case. Interestingly, the record labels, and I talk about this in the article I spent, AI, gray generative AI and its impact on marginalized communities. The record labels actually have been suing OpenAI and all these companies that create AI music, and they've been going after them, which is a shock to us. It's like, whoa, wait a minute. Now all of a sudden they're like, fight the power, defend the artist. What's going on? Not normally their normal position. Okay, this wasn't consented. And it was taken down. Universal Music, big record label, had it taken down only because apparently there was an uncleared sample in the work that the AI loaded, and they got rid of it that way. But they didn't have a copyright case, interestingly. When I look at this, I say these AI works are going to mine data from African American music because that's the music that everybody on the planet wants in Thailand, Germany, Buenos Aires, New York, and here. And so I'm concerned. Yes, I'm very concerned that is this going to be a new source of victimization of these artists? The history here isn't great. And ironically, the entire American music industry was built on impersonating African American voices way back to Al Jolson, who sang Mammy, Mammy back in the 30s, to Led Zeppelin, who I think is a brilliant band, but 100% derivative on blues artists like Muddy Waters and others, to Elvis Presley. And I am not an Elvis hater. I think Elvis, honestly, I think Elvis has gotten a bad rap. I know a lot of people, have called him racist. There's really not a lot of evidence to that. I've never been in that camp. He was a man of the 1950s. So, yeah, he probably was a little racist, but it wasn't like he was this white supremacist. I think that's false. And I like Elvis. He was a brilliant artist. However, Elvis, if you listen to Otis Blackwell, who wrote a number of his biggest hits, including All Shook Up and Don't Be Cruel, he sounds just like Otis Blackwell. Listen to Otis Blackwell, listen to Elvis, you'll have a hard time telling them apart. Otis Blackwell is the one who taught Elvis how to really sing. And by the way, American copyright law has never protected the voice. And so voice has fallen into this gap that in some jurisdictions is protected by the right of publicity, like in California, others not. But here's the thing, in California, we say it has to be your voice under the statute. And this isn't your voice, it's a digital replica of your voice. We also had a lot of shenanigans, and I talk about this in the documentary. It's called Paid in Full. So there's Mo Levy. Mo Levy was a gangster. The music business in the 1940s, 50s, 60s, even in the 70s was full of gangsters. And he was just a straight up gangster. He was a manager, or whatever you want to call him. The bottom line is that when Frankie Lyman and the Teenagers, who performed the hit song "Why Do Fools Fall in Love," Jimmy Merchant and Mr. Mercado learned that they weren't receiving any money from this #1 global smash records. It was a global smash, international smash. Why Do Fools Fall in Love? And he went to the office of Mr. Levy and said, "Hey, I'm not getting any money." And Mr. Levy said, all right, kid. All right, whatever. I'll look into it. Come back." He comes back the second time, and Levy says, he asks about his money, and Levy says, "If you come back here again, I'm going to have your legs broken." And so they never received anything. Not only that, Mo Levy had his name put on the copyright certificate, even though he doesn't write. So we have a history here of this that goes back a long way and continues into the 70s, maybe the 80s, that we're concerned about. It's happened again with TikTok and all these TikTok dancers not getting credit for their dances, someone else taking credit. I joke with my students that there wouldn't be a TikTok if it wasn't for little black girls, little black teenage girls. They drive every trend in the music industry, in the fashion industry, and on TikTok, right? And the question is, are they monetized? And the short answer is they aren't. Okay, I'm going to skip through this. my work talks about how performers are very, very badly treated. In other words, the person who didn't write the song but sings on the record, horribly treated. These are all concerns going forward with AI. I have to skip through this. You might remember Martha Walsh, Everybody Dance Now. Yeah, that was a vocal appropriation. They told us to record some tracks for, a demo, and it ends up being on one of the biggest hit records in the 90s. Finally, after years of litigation, she was able to get some measure of justice. So I'm just saying there's all sorts of precedent for this before AI. Now imagine what happens with AI under this. Why do this work? This guy called me, it was too late. His case had already gone up to the Third Circuit and he lost. And I told him, when your case goes up to this Third Circuit, Second Circuit, Ninth Circuit, Federal Court of Appeals, you're cooked. I mean, the only next stop is the Supreme Court, and they're not taking your case. They take 1% or 2%. So he was screwed, but I have no doubt this just happened. This is not some old problem from years ago. This is now we're talking about. Microsoft ended up owning the rights to this game, Gears of War, which was created by Skip's roommate. Skip had a roommate, and the guy said, I'm making a video game. Skip didn't want involvement in it because he thought the video game was negative, and he's a very positive guy, and there was negative aspects he didn't like. Next thing you know, this guy makes a video game. It's acquired by a video game company, which is basically later acquired by Microsoft, one of the biggest corporations on the planet. And he's saying that they have taken his likeness in making this character. And he had horrible lawyers who screwed his case at the trial court level. If I had been there from the beginning, I could have helped him, but it was too late. He already had an appellate court decision against him, right? You'll never persuade me that this isn't him. All the facts are there. His roommate created the game, so he knew him. Many aspects of this Cole character and Skip's persona are the same, but he lost his case. And now he basically, when he called me, he was living out of a car, okay? And Microsoft is making millions of dollars. This is not justice. This is why I do this work, right? And somebody has to say it. And I know some people won't like it, but that's no reason for not saying it. They had everything: his outfit, his costume, a voice. He has a deep, gravelly voice. They used everything against this man, but yet he couldn't prevail in that lawsuit. As I said, in California, voice is one of the categories, but it has to be your voice. Now, under the common law, you could have a claim because they used Bette Midler, the singer's voice, in a Ford commercial, but they didn't use her voice. They used a singer who sounded like her. And under the common law, the California courts have said that could be a claim, but not under our statutory law. Okay. I think I'm going to skip through some of these. Lots of right of publicity cases in AI now. This guy is a reality TV star, and he's saying that a company that allows you to switch faces, basically, an AI company, has used his face in that app, and he's going after them. That's the first right of publicity lawsuit we had last year. I don't know where it is now. I'm guessing settle, but yeah, we're probably not going to get a lot of case law out of this. Okay, I'm going to skip through this just in the interest of time. Okay, finally, I told you initially that there's all this action in Congress now to grant a federal right of publicity for people's name, likeness, image, and the like. There's a number of them. There's one called the No Fakes Act. There's one I think called the Deep Fakes Act. I'm not going to get into the minutia of them. In Tennessee struck first. They passed the Elvis Act just earlier this year or late last year, and that law says that you cannot imitate someone's voice using AI, make a digital vocal replica. Now, when I look at the Elvis Act, I laugh. I can't help, sardonically, because it's the worst named act ever. It should have been named the Otis Blackwell Act. Otis Blackwell, who Elvis used to basically mimic, was it? But Elvis, that's the wrong name for the act. Please, Tennessee, change the name of this act, please, for it. You can't use someone's voice or even an imitation of their voice made by AI for commercial use under the Elvis Act. So, Tennessee, can you believe this? Tennessee is ahead of California. Who would ever have seen that coming? They jumped ahead of us. They have the best right of publicity now in the country, and down in Tennessee. OpenAI, by the way, Scarlett Johansson is saying that they're their version of Siri or version of Alexa, which they call Sky, is her voice. She hasn't sued yet, but they say that she's hired lawyers for that. There's Scarlett Johansson there. She's going to be coming after Chat GPT because she says their vocal, whatever, I don't know what to call it, vocal assistant that you ask stuff is actually her voice. That'd be a very stupid thing if it was her voice, wouldn't it? Under this Elvis Act in Tennessee, it's not only the sound recording, but also digitally generated recordings. In other words, AI generated recordings will be prohibited. You'll need to get permission to use that in a commercial way in Tennessee. Of course, as I said, there's deep irony because Otis Blackwell, who wrote All Shook Up and Return to Sender, there was no protection for his voice, but now there can be. We also learned that Otis Blackwell had to share copyright with Elvis, even though Elvis doesn't write songs. Okay, I'm going to skip through these because we're getting close to the end. So the No Fakes Act, as you see, says only applies to vocal replicas that are used in sound recordings for it. And I'm just saying, okay, great. First of all, we've wanted a right of publicity for like 25 years, ever since I've been in this game, and never could get one. And I think what has pushed it is partly some of the horrible sexualization stuff, where people doing fake pornos, putting your face on somebody's face. Horrible, right? Agreed. I think that kind of spurred it for it. But I think we need to go much farther than what these acts are giving us. Just focusing on digital replicas isn't enough. Why not just say that there is a federal right of publicity in everyone's voice, and no one's voice can be appropriated for commercial purposes? Why just digital replicas, right? And not real people? That doesn't make a lot of sense to me. So my fake sound is actionable, but someone who used my real voice isn't actionable. I'm also proposing that since Congress wants to open up this box and make legislation about right of publicity and AI, that they should also make a federal right to credit. This is by the way, this is more important to me than anything else. Because if you deprive a person of credit, you deprive them of money. You deprive them not only of money, you deprive them of dignity. And so we don't have a federal right of credit since around 2023, I'm sorry, 2003, when Justice Scalia, the late Justice Scalia, in his infinite wisdom on the Supreme Court, said that there was no right to credit for an artist, a performer, under the Lanham Act, the Trademark Act. Since then, the only way that you're entitled to credit is through a contract. And we know that people who are not, who are at the bottom aren't going to be able to have negotiating power to necessarily negotiate the credits that they deserve. So any new federal tinker include a right to credit, in my mind, such as these young girls who are creating dances on TikTok, right? They should be credited because when they're not credited, they're deprived of opportunity and they're deprived of money. There's no legal requirement right now to give these young girls who create these dances credit. And that's untenable. Attribution credit is a fundamental right under international law. Every other country does it. For whatever reason, America doesn't, right? It's called moral rights in other countries, and we have signed treaties, specifically the Berne Convention, which says that you have to provide rights of integrity and credit to authors and people who create stuff. The U.S. skirted around this by just giving it for fine art in the Visual Artists' Rights Act. But everybody else is not entitled to these moral rights of attribution and integrity. Okay, I'm about done with my presentation. I wanted to leave time for some questions, and I hope you enjoyed it. Thank you for giving me the opportunity to kind of workshop this, and ultimately it'll turn into a big, beautiful article, and you guys will be in my gratitude because you allowed me to bounce my half-baked ideas off of you.
Okay, so now for the Q&A portion of this class. So one question we have is, do you think it will be possible for Congress to create a federal law relating to right of publicity? And what are some of the issues that you think that they will face with trying to create like a federal law for that?
Great question. Thanks so much. You know, if you had asked me this 6 months ago, I would have been much more optimistic, quite honestly, because they were really going guns a-blazing. It's like, oh, great, they're really going to do this. Um, Now, I think it still could happen, but as your question indicated, there's all sorts of landmines and and things in trying to do a federal right of publicity that may prevent it from happening. I mean, one big question is if we're going to have a 50-state right of publicity, what's the duration of it going to be? In California, just for example, the right of publicity lasts same as the copyright term. So it's your life as the person. So your whole life, you get copyright, and then you get an additional 70 years. That's one big sticking point. Some states may not want to have one, quite honestly. What do we do with them? Are we going to keep all the state laws? Is this going to preempt them? So there's actually more questions than answers about to all of those things that I just raised that make this a very, very difficult undertaking. And then there's people like me, who are saying, no, wait a minute, while you're doing this, if we don't give a right to credit now, I don't think we're ever going to do it because this is the time. They're talking about the right of publicity. They're thinking about the right of publicity. For whatever reason, the people who normally opposed the right of publicity, and you know who I'm talking about. Yes, you, Recording Industry Association of America. Yes, you, Motion Picture Association of America. Now they're just Motion Picture Association. What happened to the other A? I liked it was MPAA. Now it's MPA. That doesn't sit well with me. I saw this guy from the MPA get up and he said, "Oh yeah, I support this." And I was like, "Huh? What's your game?" Movie studios hated the right of publicity. They have to pay people more money, right? They have to give people more rights. They didn't like that. So something shifted. I'm not sure what. And I said, okay, great. The movie studios aren't opposing this. The normal people who opposed it weren't opposing. So I think there's still a good chance we're going to get a federal right of publicity, bottom line. I think it's probably going to be very ugly, though, because I don't know how you could satisfy all those people.
Okay, let's see. Another question we got is, do you think this will lead to a broad coalition for change in legislation at the state or federal level to protect artists and performers? So,
I mean, I think that's true. I wish that were true, but I don't see that happening. Because the the ones who had unions obviously were protected and they did well. Presumably they're out of the game, right? They got their protections. I don't know. Maybe that should have been part of the strike, right? It really didn't become part of the strike. And for it, there are some organizations that are pushing this, and some of them do have the ear of Congress. So that's positive. I'm thinking particularly of the Black Music Action Coalition, and I've done some work with them for it. They're actually sitting down and they're in the room with the big studios, record labels, and also members of Congress. So, it's going to take time for it, but I don't see a movement right now to answer your question succinctly.
another question was reparations. Can we start a movement for it related to reappropriations of culture via AI for folks of color? Is that a reasonable right of credit claim?
I mean, that's a great question too. As you know, here in California, we did have the historic first ever reparations task force. That task force met and they reported out their recommendations, but it's America and it's politics, and reparations is a very, very contentious topic. By the way, the stats have gotten better on reparations. There was a time when like 90+% of white people, like they hate reparations, and 90+% of Black people think reparations is a great idea. So it was a big goal. That has shrunk significantly. So, and this is the same thing we saw with gay marriage, right? That, people were adamantly against gay marriage. And then over time, because of advocacy, those numbers shrunk and shrunk and shrunk. And now I think it's not even a majority of people would be against people of different, genders getting married. So the gap is closing. There's still a long way to go, though. And I don't, that reparations task force said the state of California should pay out. but it's held up and new. I think he's political too. He wants to get reelected. So I think the short answer is no, but we have to keep chipping away.
Okay, and
That's
then
a great question. Thank you for that question.
the question before that, when I asked about the broad coalition for change in legislation, the individual who asked the question wanted to clarify that their question was about whether a broad racial coalition would be likely. I don't know if that changes your answer.
I mean, that would be ideal. I mean, that goes back to Derek Bell, who talked about interest convergence. And Derek Bell, the founder of critical race theory, said that basically you need other groups. You know, you can't do it alone. And in order to get those other groups, you have to get something that they want. It's just human nature, right? People want something for themselves, right? It's not a bad thing. And so finding those connections would be great, but I think people have been trying to do this for a long time without a lot of success. So I'm not too optimistic about it. Yeah, we should think about some particular moment or some like George Floyd was a moment, right, where we all came together. That's one way it happens, or a particular issue. Is this the issue to do it? I'm thinking not, but anything's possible.
Okay, and then another question that we have is, do you see other states following Tennessee with enacting laws like the Elvis Act? And then how would this apply to like international markets?
Good question. So in terms of the first one, I think New York already has done this, if I'm not mistaken. So others are doing it. I'm sure California, I heard there's a California bill that's already about to pass too on this issue. So I think we will see that. But one of the things about one of the reasons to have a national right is so you don't have all this variation, right? And also, I know nobody in this call cares about it, is so-called forum shopping. So right now, if you really want to know the truth, the state that has the strongest right of publicity is probably Indiana. There's a company there called, what is it called? WX Marketing. I forget the name of the company. They own the rights in dead celebrities. And they went to Indiana and they set up shop in Indiana, and Indiana has like really strong right of publicity laws. Do we really want that? Supposedly we don't. That's why we have a federal system. So we'll see what happens. Stay tuned. I'm sorry I can't be more specific.
Okay, and then this wasn't a question, but somebody just said, excellent presentation and a lot of information to digest. Wow.
Well, thank you. And you know what? I'm workshopping this, so a lot of it will hopefully get better as time goes along and get clearer. But just from being here and being able to talk to you, like helps me tremendously in thinking this stuff through. So thank you, Nicole and Law Library, and thank all the people who attended. How many did it end up being at the end of the day?
We had a total of 29 attendees.
All right, and they got that good. I know the elimination of bias credit is hard to get, so I'm glad they were
Yeah.
able to get that.
And then we just got another comment that said, great presentation. I think we have time for one more question. So feel free to utilize the Q&A.
This is very rewarding for me because I presented this the last time I gave this talk was at UCI, and the professor didn't say it, but I got the sense the professor didn't like the presentation. The audience did, but the professor who invited me didn't. So you gave me a little bit of encouragement. Thank you.
Well, we just asked if we could have more presentations like this from like that the San Diego Library hosts. So
Great.
I think that this has been an absolute fantastic presentation, wildly interesting, a lot to think about for sure.
Okay, well, thanks. And I did share my article, so if you want to share it with people, certainly, if you want to message me, you can give me feedback on that. On Facebook, I'm Kevin J. Greene. On Instagram, I'm Hip Hop Law Prof, I think. And I'm also on LinkedIn. So.
Okay. And then we got one more compliment. Thank you for the presentation. Very interesting. Please bring back Mr. Greene.
Thank you. Thank you so much.
we are all very appreciative of this presentation. Somebody asked if they would be able to get the slides. I did send out the handout, the article that you sent before. I sent that to everyone prior to the class.
Okay, I'll send you the slides.
Yeah.
I noticed a typo. I had your name spelled 2 different ways.
It's Nicole, but if Mr. Greene agrees to give the slides, then I will, if you send those slides out to me, then I can send them out to everybody else.
Sure, probably later today because now I have to hop on a faculty meeting.
Yeah. And then
Yeah.
for everyone, please look at your email for the MCLE certificate. And we appreciate you guys joining us. Thank you so much, Mr. Greene, for such an amazing presentation. And we'd love to have you back. But we know you're a busy man, but thank you so much. We really
Thank you,
appreciate
Nicole.
it.
All right, have a great day.
Bye, everyone. Thank you for
Bye.
attending.
Bye.